All right, everyone, welcome. Thank you for joining us today. I'm Kate Stedman with Choice Residential, and we're so honored to have you here with us. At Choice, I know I speak for all of our agents when I say that our goal as agents is simple, to be a resource for you in all things homeownership, not just when you're buying or selling, but long beyond the closing table. And a big part of that is connecting you with trusted experts who can help you protect what matters most, which is why we're so excited for this session to partner with Rasmussen Law for Trust Made Simple to help make sense of what can be sometimes a complicated topic, something that's definitely trending and that we're hearing more and more, but definitely need some information on how to do it for ourselves to give you practical tools to safeguard your home and legacy. So if putting your home in a trust is something you've considered, you're in the right place. With that, I'll hand it over to Deb with Rasmussen Law to get us started. Deb, thank you for doing this today. And to all of you, thank you for your time. We appreciate you being here.
Yeah, thanks so much, Kate. And I'm just thankful for Choice Residential. I think this relational way of dealing with your home is so important. I think your agent being there for you when you have questions and also to add to your knowledge about, what's happening with your home and how to better protect it going on. I mean, I just think it's great. So super happy to partner with Choice Residential to do this. And I'm going to go ahead and share my screen, and because I made a pretty PowerPoint for you, and hopefully it can demystify something that can be a little bit difficult for people to understand, but we really do try to make it simple. And I think understanding how your home interacts with the laws of North Carolina or another jurisdiction, if you have maybe a second home somewhere or a rental in another place, is going to be really important for just being predictable for your family and peace of mind for you right now. In our practice, we explain these things at multiple junctures throughout the planning process. So, and I think our clients are some of the smartest because they've had it explained so many times. We answer so many questions, and hopefully you'll have that same experience today as we talk about just kind of some of the basics about trust. So this is me. I'm an estate planning attorney. Before I became an estate planning attorney, I was a mama bear who raised four humans, and also I was a business owner. And right before I went to law school later in life, I became a paralegal. And as a paralegal, I ended up in charge of all the estate planning documents at a real estate law firm. And I loved my real estate background, the things that I learned as a paralegal there. But I thought that estate planning was pretty boring because we were just doing one size fits all documents for everybody. And that's not malpractice, it's actually common practice. And now we have websites and AI that want to do the same thing for you. And I thought that we had given a lot of people peace of mind. So you can imagine that how shocked I was when I learned that a will does not save your family from interacting with the probate court when you die. I thought if you just made everything known what you were going to do, you didn't have to interact with the probate court. So I was pretty shocked when I learned that wills trigger the whole process. And I had been a part of creating a whole bunch of wills. And that just started me being super interested in all the ways that estate plans could fail and what I would do better if I ever had the chance to do it. I didn't think I would be an estate planner ultimately. I was just writing down my ideas, never thought I'd start a law firm. But here we are. After law school, I saw estate planning done in pretty much the same way as before I went to law school. And I thought we could do better for families. And that's when Rasmussen Law was born. Maybe we're kind of a protest law firm because we have a very specific way that we like to take care of people through the entire process, help them understand what's going on. Here is my cute family. That's my husband, Lars, my oldest daughter, Samantha, and then Joshua, Daniel, and Noah. They are my oldest three are college age, and my Son Noah, the little one, right there on the right, is a missionary right now in Chile, which is kind of fun. Just a couple of professional associations that I belong to. I did go to Campbell School of Law after graduating from BYU for my undergrad. My undergrad's actually in linguistics, which makes wordsmithing really fun in wills and trusts and other legal documents. I have minors in Chinese and Japanese and belong to the J. Reuben Clark Law Society, which protects religious freedom around the world, which is super cool. Personal family lawyer, that's a designation for estate planners that really care. And Wake County Bar Association, Apex Chamber of Commerce, Wake County Estate Planning Councils. This just means that I don't know, maybe we know what we're doing on some level. We're trying. We're trying to give the best possible information that we can. So let's just start on the same page and talk about estate planning 101, understanding the fundamentals of protecting your legacy, and then we'll get really specific with what to do with your home. All right, so there are a couple different ways that assets are passed along. It doesn't necessarily mean that everything is going to be governed by your will or your trust. Some things are jointly owned and everything goes to the survivor. Some things go by beneficiary designations. So they're, Charles Schwab or Edward Jones, they're not going to ask fidelity. They're not going to ask what's written in your will. They're going to pay out to whoever's on the beneficiary designation. Then there is probate, where we don't know where things are going and it goes to your estate. Then we have to deal with a probate court. Now, as far as your home, there is the NC, the North Carolina special rule that your deed, if there's no other thing that governs, is going to be vested in the heirs. And we'll talk about that a little bit later. It's a special rule and it sounds like it's really going to do some magic, but it does actually create some problems that I want to let you know about. All right, so here's the big myth. A will avoids probate court. It doesn't. And anyone who's had to deal with a probate court doesn't have very good stories to share about that. And most people want to avoid this for their family. I like to say, I mean, on average, the delay for everybody getting their inheritance is going to be 12 to 18 months with a probate proceeding. And has the probate court has all the efficiency of the DMV. So if you can remember the last time you went to the DMV, how fun that was. Imagine that were your new part-time job for another 12 to 18 months, or you gave that part-time job to one of your kids. This is what we're trying to avoid with trust. Okay, so everybody asks the question, do I need a will or a trust? And when I'm talking about a trust today, we're talking about revocable living trusts. And the main job of a revocable living trust is to avoid probate, for your loved ones to not have to interact with the court when you die. Okay. Do you need a will or a trust? The answer is I don't know. I actually don't know until I know every single thing that you own and sit across from you as we talk about how the law interacts with all of your assets to see how much you actually care about that. And we have a system in our firm by which we do that. We actually sit down for 2 hours, and this question is kind of the forefront thing. And once we talk through all the assets, it does become pretty clear what needs to be done next. So this is a question that unfortunately we're not going to be able to answer completely today. But once you learn more about what a trust can do with your home, you are going to have more points of data as to whether or not you really want one. So that's our goal today. A trust is like a red wagon. So assets that are held in the trust are like toys safely in the wagon. So think about each of those toys in this little girl's wagon as the different assets that she owns. Everything that we get into the wagon is going to be governed by the trust. Imagine that this wagon has a big fat sticker on the side of it that says, hey, when stuff lands in this wagon, here are my rules for what I want to have happen to my stuff. Great thing about this is that there's privacy. Unlike the probate court that is a public proceeding, this is handled privately. It's in America, we have freedom to contract, and a trust is just a contract with yourself made in advance, which sounds like you shouldn't be able to make a contract with yourself. But in America, we say, oh, that makes sense. And we all nod our heads to this legal fiction that we are contracting with our future avatar, and it works out great. We have control of everything that's in our wagon. And what's nice about that is if something happens to us and we can't make decisions about what's in the wagon, we just hand that little wagon handle to someone else who can then make the decisions for a while until we come back. And there's no probate. So when things are safely in the trust, we're not triggering this court proceeding that everybody wants to avoid. Now, what I want to make clear about revocable living trust is that they do not provide asset protection for the person who created the trust. Okay. So just to make that really clear, we're talking about revocable trusts. Irrevocable trusts are maybe for another day, but your revocable living trust can be the vehicle by which we could add some little sidecars, some little pieces behind this wagon to create asset protection for someone else. Okay, so toys outside the wagon create problems, and we know they do because look how sad this little girl is. Her toys are outside of her wagon, and she is just like, what am I going to do? And we see this happen a lot. People make a trust, they spend thousands of dollars to create a trust, and they don't do part two, which is make sure that your assets get into the trust. Some things are appropriate to hold in the trust and some things aren't. All that has to be spelled out and planned very specifically. When we sign a trust, I just did this morning with some clients, I always say, congratulations, you just created an empty bucket or an empty wagon. Okay, there's nothing in this yet. I don't want you to have peace of mind yet until we get to step two, which is putting things inside the trust. Um, when the toys are outside the wagon, we're going to have an empty trust. We're going to have delays because some of these things are going to have to go through the probate court. There might be some family conflict regarding what happens to these things. And it's unnecessarily expensive at a time when death and money are already messing with people's heads. Okay, so this stuff taken care of in advance is very powerful. So let's talk about protecting your home. And congratulations, your home is very beautiful. I put a picture of it right here with you. I actually loved the look, the curb appeal of this house. I thought it was appropriate. Your choice realtors can tell me if this is actually a good pick or not. But let's talk about the home. So when a surviving homeowner dies, and I say surviving homeowner because a lot of you are owning your home jointly with your spouse. And when the first spouse dies, it's just going to go to the surviving spouse, and there's not a lot of concerns at all. Where we do have a concern is where now the home is in one person's name. So here's what happens. Without a trust, the probate court must give permission to sell the house. So if we've done nothing and it's going to vest in the heirs, that's that little 2-year rule that we talked about. If we can't turn around and sell it right away without doing a notice to creditors and dealing with the probate court on some level, this can cause a delay. Average is 3 to 5 months. During that whole time, the family might have to use their own money to maintain and repair the house because they might have not been able to get access to funds in the estate yet to do those things. Someone's going to have to keep the lawn mowed. Someone's going to have to update the insurance, pay the utilities, and get that house ready to sell or keep it looking nice to sell, even while we're waiting for those 90 days. Family conflict can create even more delays, and I'm sure you have heard stories about that. And this all becomes part of the public record. Remember, the probate court proceeding is a public record. With a trust, it's a totally different scenario. The successor trustee can turn around and list the house right away because the house is already trust property. Funds from the trust account can be used for repairs and upgrades to get it ready to sell. No court approval is required. and all those distributions are private. Now, when a surviving homeowner is incapacitated without a plan, the will is not in effect. Okay. And if we don't have other things to say who can do what, we might have to have what's called a living probate proceeding. That is where someone who's incapacitated has to come in a probate court, and all of the evidence is evidence of their incapacity, which nobody wants. Okay. So planning for incapacity is very, very important. Sometimes the accounts are frozen until a guardian is named, and the POA may work or it may bar action if it's outdated or not state specific or for other reasons. Sometimes they pass it to the legal department until someone has time to read it. And this always seems to happen right about the time when we want to access the funds. Now, with a properly drafted and funded trust, incapacity is privately determined. The successor trustee can manage and sell the property. Funds from the trust account can be used as needed. And the incapacity provisions in the trust trigger the incapacity provisions in the power of attorney. And we need both to be working effectively. And one of the questions I ask, how does that work? If we have a trust for incapacity and we also have a POA, well, the trust is going to apply to the things that are in the trust, to the trust property. But there's plenty of things that are left outside of the trust, and we're just using the trust and beneficiary designations, like retirement accounts and life insurance. So in order to manage those accounts or make changes to those, then, or even to get your mail from the post office or all the other things that you do adulting in your life, you need the power of attorney to cover you. It's actually very, very broad for all of that. Trust for trust property, power of attorney for everything else. Okay, so I need to underscore this point. Trusts only work if the trust is drafted correctly, the trust is set up correctly, the home is deeded into the trust and recorded. That's very important. And sadly, we see unfunded trusts all the time. That's why we gave you a picture of an empty bucket. It's like, congratulations, you just created a very expensive empty receptacle. And unless we've done part two, we're not done. And that is kind of the genius of a PFL firm. I told you about that designation that we have, is we have full support through the entire funding process. You'll know when you're done with us. Okay, so here's some best practice. So we talked about your primary home and putting that in your trust. Here's best practice for rental property some of you might have. What we like to do is deed your property into an LLC and then have that LLC interest assigned to the trust. So instead of you holding that interest in your LLC, you're saying, oh no, it's my avatar, my trustee who is holding this interest, which is really great because when you die, that interest just goes to the successor trustee who can take care of it. They can sell the property, they can continue renting it for the benefit of your beneficiaries. They can do what needs to be done without a probate proceeding for the LLC. Property plus an LLC will avoid probate for the LLC. Second homes are a little bit different. We love the LLC for rentals because there's some asset protection in the LLC. You want that separate from yourself in case some rentor, short-term or long-term, decides they want to sue you. You want that separate from your regular assets. But second homes, we're not as worried about that. This is just our family that's going to use the property. We don't need the liability protection. And we can just deed that second home directly into the trust, and then there's no confusion of what happens to it when you pass. Legacy property. Let's talk about that. It's a little bit different. Think grandma's lake house. There's a couple options there. One is to manage it through an LLC with clear family rules. You want family ownership, but maybe you want people to be able to sell their share and go in and out of the family LLC. Rules can address the inheritance, buyouts, decision making, and an operating agreement should allow each person to assign their interest to their revocable living trust. That way it is clear again what happens to that share when they pass. Another alternative, and something we just did recently, was we put the legacy property directly into the revocable living trust. And we drafted that trust so that that trust became a dynasty trust, which means this property is in this trust for a very long time. In this case, it was multiple properties that will stay in the trust for the use and enjoyment of the family. They didn't want people to be able to buy and sell shares of it. They just wanted it to be for the family forever. Well, we do have something called the rule against perpetuities, which means we don't like things to last forever, but they can last forever in a trust or actually in an LLC as long as you don't have a rule that says nobody can ever sell this. As soon as we see that kind of rule, the North Carolina statutes want to kill it because that means that we're becoming like, I don't know, old English landowners, and we're going to lock it up for the royalty instead of letting everybody buy property. But as long as we say, hey, I really don't want anybody to sell this property, um, it's not a prohibition on selling it. You're just saying what your wishes are, and you can keep this property in your trust in perpetuity. Okay, so let's talk a little bit about those special default rules where the home vests in the heirs. And I just wanted to just say, let's not allow property by default to go to the next generation. Let's see what that looks like. I have 4 kids. So if I wasn't holding my property in a trust and didn't give it to a specific person, then it would by default vest in my 4 children when the survivor of me and my husband dies, which sounds like, oh, well, it went to who you want it to go to. Well, not so fast. That's a lot. My 4 kids can't even agree about most easy things, let alone whether or not to sell the house and what to do with it. But as they get married and have spouses, guess what? Their spouses also have to sign out on on doing something. What if you had one spouse of one of the kids that was like, no, we want to live in that house, or they just don't agree with everybody else and they won't sign off on it. This is where you get into family conflicts. So we really want the house to be in the control of a trustee that's using it for the benefit of the beneficiaries instead of belonging to the beneficiaries. Unfortunately, what happens because of this rule is that it gets so confusing with so many heirs and who these heirs are and who died first and who their spouses are and when they got married and all those things that it can go now from generation to generation. Now we have so many heirs and we have to do some very complicated court things to account for the heirs that we can't even find. Okay. In order to get clear title, once has happened, the 4 heirs, let's say it's mine, they could get clear title after 2 years have happened in the 4 of them, which is not ideal, but at least they could potentially sign a document and sell the house. But it's going to take a delay, right? Because if we want to sell it before 2 years, which I promise you my kids do want to sell the house and just get their money, it's still going to be a 3 to 6 month delay. And some of them don't even live in North Carolina anymore, and they won't want to be taking care of the house. This is just an unnecessary expense and delay. So, who are the heirs is a problem. The unsolved problems increase exponentially with every generation and their spouses. Have a plan. This is what North Carolina's alternative plan looks like. We want you to have a better plan. Okay, out of state or out of county property. So with a trust, the lot of situs governs. Okay, so if we die and we have property in Wake County and we live in Wake County and we haven't put it into a trust, then we're dealing with the Wake County probate court to get permission to sell. Okay, what happens if you moved to North Carolina from another state? Well, and you left property there. You have a rental in another state. Well, now we have something called ancillary probate. Now a probate proceeding has to be opened in that other state. But not only that, let's say you have property in another county, which I'll bet some of you do. Another probate proceeding has to be opened in the county, even if it's in North Carolina. If it's in a different county, then it is governed under the probate court of that different county. So if you have out of state property, and you're using it as a rental, then we use our rule to put it in an LLC and assign that interest to a trust. If you're using it as a second property, then we could deed it right into your revocable living trust. And guess what? Once it's deeded to the trust or deeded to the LLC governed by your trust, then you are avoiding probate altogether because you did the thing which was put this property in your wagon or tied it to your wagon. That's what we want for out of state or out of county property. Okay, some insurance considerations, and I don't think we talk about this enough, but if the title changes, your insurance needs to be updated. So if you deed it to the LLC, an LLC needs to own the homeowner's insurance policy. If you deed to a trust, the trust needs to be added as an additional insured. And if you have an umbrella policy, you should also add the trust as an additional insured. I know that's a lot of information, but I know that we're recording this and you can come back and feel free to screenshot anything. Okay, I always have to talk about this every time we talk about anything. Do not add your child to your deed. And I know you're thinking, wait, what if I add them to my deed as a joint owner, then if I die, then they're the owner, right? It makes perfect sense, but it causes some problems. Your child loses a step up in basis. So what that means, let's say you bought a property for $400,000 and you added your child to a deed because you're like, hey, I'm being smart. No, I don't have to have an estate plan. I just have to, give this to the kid when I die. Well, let's say you live for a long time and houses do what they do. They're great investments. And your house, when you die, is now worth $700,000. Okay. Great. That's fantastic. Except, guess if this child lost a up in basis, it means they inherited your basis in the house, which is the amount you bought it for $400,000. And now they are on the hook for the $300,000 capital gain. Okay. That is a large tax bill. At 50%, let's assume it's 15% long-term capital gains, that would be $45,000. And that would be really, really dumb because guess what? If you leave it to them instead through a trust and will, they get a step up in basis. You would have given them a $700,000 house that they could turn around and sell pretty quickly with almost no capital gain at all. Okay. So I get what people are trying to do, beat the system. But every time I speak, I talk about this, and I always hear someone who has either just added their kid to a deed or just been added to their parents' deed. So, whatever you do, there is a way to reverse this if this has happened to you. It increases tax liability. It increases creditor risk because now, let's say that you don't have any real creditor risk, but and the kid that you added to your deed, let's say, I mean, this girl right here, she looks like she could be, let's say she's a doctor. Well, if she gets sued and maxes out her malpractice insurance, guess what comes up as an asset that can be collected from for her? It's your house. That wink and a nod, you both know that it's in your name, but guess what? The law doesn't see it that way. She's a joint owner, and her portion of the house could put the house at risk. So there's a loss of control too with this. What if your child changes their mind about you wanting to sell it, or you wanting to refinance, or you wanting to put green carpet that you've always dreamed of, and now they have this joint ownership and more control than they need. Very easy fix to this. Instead of doing your own lawyering like this, it's to just put the house in the trust. You can have your child help as the trustee of your trust. They can even be a co-trustee with you. But we need to avoid all of these other problems. Okay, and then something I didn't talk about last time we spoke, but I felt that this might help someone today. So I'm just bringing it up. It's called a right of occupancy. This is something you can do in your trust that's a specific gift to someone you love, and maybe someone who kind of needs a leg up in life. You can give a beneficiary the right to live in the house after you're gone. The house is still held in your trust. The trustee manages the property and provides oversight. The beneficiary might share in the expenses. You might say, hey, you got to pay for utilities and whatever else. But it's a great option for a beneficiary who can live independently but needs assistance. Someone who can't quite manage their stuff 100%. So if that speaks to you, what you might need is a right of occupancy for someone that you love in the house that you own, so that they don't have to go find somewhere else to be. They can be where they are used to being. Okay, business owner considerations. And we talked about that a little bit, talking about the rental LLCs. If you have a single member LLC or partnership, assigning your interest to a trust is a great way to avoid probate for your portion of your business ownership. The successor trustee can take over without probate. Sometimes they don't have the same, if it's a partnership, they might not have the same voting rights, but that's fine. The ownership is still there, and you can deal with that share, exit strategy, whatever you need to do. And if it's an S Corp, C Corp, anything else, we have fantastic business attorneys that we work with that can actually retitle those shares in the name of a revocable living trust, so we don't have these interests hanging out there. Okay, so what about your family? And we kind of need to think holistically. This is a very cute baby on a stack of money, but I'm telling you already, I can tell by looking at this picture, this baby is very financially immature. Okay. Not only that, but if we are going to give this baby all this money, other people might become very interested in this baby and be like, oh, I think I would love to be the guardian of this trust baby. And if you have multiple people on both sides of your family who love your kids, then this might become a point of conflict. We do something called a kids protection plan. So not only are we thinking through what happens to beneficiaries who are not financially mature, but they might have other risks too. They might have something that we call lifestyle defects. This is a term that we have coined to include things like incarceration, drug addiction, disappearance, big spending problems, things like that. I am not of the opinion, as a mother first before I'm an estate planner, that getting the most money possible to the next generation is the best thing that you can do. Some children can self-destruct with $10,000 pretty easily. And if we need someone to look out for some of their interests sometimes. And you probably know which kids we're talking about. You might have kids that you have no problem. They're going to get their inheritance outright and they are of age. But you also might have ones that you think, maybe we need a little more time for the frontal lobe to develop before we give them a $100,000 life insurance policy, for example. We also need to talk about guardianship. We have a kids protection plan, and this is something that we do for free no matter what level of planning that you do for us. And I think every lawyer who does an estate plan should do this. Most lawyers only name guardians in the will, which means the will has to be authenticated through a probate court before it's legally effective. To me, this is not acceptable. This is a gap in time where we're not sure who's going to come forward to care for your kids. So we name guardians outside of the will for the long-term guardianship, but also you need short-term guardianship. What happens if you and your spouse cannot get home to your children tonight? Who will step forward to take care of your kids that lives right close by until your long-term people can arrive? We all need a list of this. If we have minor children, we need people who have authority to step in. So our kids protection plan not only includes the long-term guardians outside of the will, short-term guardianship of friends and neighbors who are supportive, family members that are close by, but also instructions on how you want your kids to be raised. Because just saying who does it isn't the whole story. Um, if are you needing probate avoidance, then maybe you're thinking about a revocable living trust. Are your beneficiary designations current? Sometimes these get lost. Sometimes you're with one retirement company and you've moved an account to another one and your retirement designations are lost. This is something you can go online right now and go and see where they are. Even better, if you have a revocable living trust, there are some really cool things we can do with the beneficiary designations. And are they adequate? If this inspires you to go into your online accounts, whether it's your bank account, your retirement account, a life insurance policy, and you've named your children as beneficiaries, there is a little box that says per stirpes on some of them. I wish they all had this. But if there's a box that says per stirpes, I want you to check it because that means if one of your kids predeceases you, then their share will flow to their children. Okay. What we don't want is if you have three kids and one of them predeceases you, leaving children, that now they're essentially disinherited because the beneficiary designation on your retirement account, which has $1 million in it, now only goes to the two beneficiaries. And then we're just hoping that they'll do the right thing and their spouse will agree and share with children who probably need it more than anybody. So that per stirpes box, if you ever see it on a beneficiary designation and you're naming a person, and you want that to flow to their children, make sure you check that box. It's a good time to think about insurance coverage to make sure you have enough life insurance. Some people are hesitant to name certain people to be guardians of their kids, even though they would be fantastic parents, because those people don't have a lot of money. Well, guess what? Your plan is incomplete then, because what you need is adequate life insurance to cover who could potentially be raising your kids for you. You need healthcare directives, and you need this protection against financial immaturity and lifestyle defects that we talked about. This cute little beneficiary, he doesn't even know what's happening with all this money, and 18 is way too soon to get all of that outright. I think that these kids need a little more time. Okay, and just a word of caution, the cheapest plans are the most expensive, and that is not a typo. And I know this because I used to be a paralegal and a lawyer who did the cheapest plans. We were trying to be the cheapest plans, but estate planning as an afterthought to another legal transaction can lead to expensive probate. You may just be paying more on the back end and adding zeros. Quick will packages miss the big picture. And DIY and online wills and trusts have the highest probate fees. A local attorney just did a survey because we're starting to see these online wills come through administration. They did a survey of everything that they've done and did averages. On average, their lawyer drafted documents that go through probate had about $5,000 in fees to get through the whole probate process. If someone died intestate, so without a will, and now we have to go through the probate court with just following North Carolina statutes, average was $10,000. For DIY or online wills and trust, we have to add that because I had one the other day that it was actually a financial advisor, had a will and a trust that conflicted each other. They canceled each other out with their provisions. And anyway, those are the highest probate fees. So on average was 18,000 and for to get it all through the process, not to mention the delay and possible conflict. Okay? We want your family to be out of court and out of conflict. And there's so all of this is entirely avoidable. So when should you plan? Well, you should plan if you have minor children, if you own a home or a business, if your current plan is more than 5 years old from another state or was created online. And actually, we like to, if it's more than 3 years old for our clients, we like to see them every 3 years just to make sure it's current and still acts like we expect it to. You should plan if you want your family to avoid probate, and you should do it now while you still have capacity. I feel like part of my job is to help people overcome their procrastination in this department because this is the thing that you think, oh, well, put your finger on your pulse today. I woke up, my dad used to say, every morning I wake up, I look at the obituaries, and if my name's not in there, I get up and get dressed. Okay. Every day feels like not the day that something could happen to your family. But if it's been at the top of your mind, kind of the little tickle in your brain, and if this helps motivate you at all, now is the time to start thinking about it if you haven't already. And now I want to do a word about legacy. So, what about we're going to switch gears here? We're talking about your memories, your relationships, your values and faith, and your lived experience. Before I became a real estate paralegal, I told you I was a business owner. And what I used to do was help families write their stories. This is part of who I was. And I thought when I became a lawyer, I had to leave all this behind. And we have found a way to incorporate legacy in the entire process. We actually bring out a recording equipment during your last meeting with us, and we capture a little bit of your voice and your family story. We also give you a list of resources so that you know where to look to record these things in the very best way. And I am of the firm belief that these things are actually way more important than your money. The average beneficiary might spend through an entire inheritance in 8 months, but these are the things that last for generations. So the home intangible goods will come and go. Average inheritance gone in 8 months. I know they're just like little NFL players, lottery winners. But your true family wealth is your stories, your faith. And I want to challenge you, if you haven't taken steps to record your legacy, to today write down a list of 5 stories that changed your life and start writing one of them. If you don't want to write one of them, just turn on your camera, point it to yourself, and start telling one of those stories. You can actually upload that to an AI. They could write that story for you, and you could just email it to all your kids. It could really be that simple. Here is some of the legacy that my parents gave me. And I'm not going to cry when I talk about this, but you can see in this picture my parents on the left-hand side. That is my dad talking. He's narrating something that he's looking at. And my mom is pointing the camera in a completely different direction, which I just think this captures who they are. You could not have two people that were more different on this earth. Neither of them had very good family situations growing up. My dad said we were too poor to afford a father. And my mom's parents got married, divorced, and remarried and divorced. Like it's a whole thing. They did not have a good example of what a family should look like. But they went forward to have 9 children, adopt 5 more. So there's 14 of us, and I'm number 12. And I think they must have just thought, well, what does the ideal family look like? What could we do? What could we give our kids that nobody had? And here's some of the legacy that my parents gave me. They gave me my faith in Jesus Christ. Sorry. They gave us a legacy of missionary work. We've served missions all over the world. My son right now is in Chile. Chile. They gave us a legacy of charitable giving, of forgiveness and not taking offense. of being prepared for emergencies when they happen. And entrepreneurship. If you look in that picture of all my siblings, there's not a single one. No, I can see one sister who's a nurse. Everybody else is an entrepreneur. And they had an open door. Everyone is welcome. There was often more than 14 of us because they had an open door policy and just humor. My dad was just the dad jokes. On his tombstone, he wanted to have, I told you I was sick. And we actually had a conversation about whether or not he was serious with that. So, with that, just think about the legacy. What are some of the things that you are passing to the next generation? And I want you to be thoughtful about this. Talk about it. Maybe make a list of those 5 stories today. Your legacy is not complete without this piece. This is the most important piece. And with that, we can go to questions. After the question and answer, I have just a couple quick slides to give you an offer today to help you overcome your procrastination in case you need it. But I'm ready for questions.
Deb, thank you so much for doing this.
Mhm.
Somehow you made contracts and trusts and things that seem legal and daunting quite beautiful. So thank you for sharing.
Yeah,
We've
no
got a
problem.
few questions in the comments, so I'm going to read through those. And then if people are interested in unmuting or providing additional details on what we discuss as we bring these up, feel free to just raise your hand or unmute as the time comes.
Okay.
Um, Ayana asked in the chat, are there legitimate reasons that someone should not put their home in a trust? And then I don't know if this is the same thing or not. Understandable that the cost of setting this up can range, but what is the reasonable expectation for this with your practice?
Okay, those are both great questions. First of all, is there a legitimate reason that someone would not put their home in a trust? And I could think there's a legitimate reason why you shouldn't create a trust is if you're not going to do part two, which is deed your home into the trust. There is some setup. People say they want things to be easy, and I always ask, easy for who? Because when you have a trust, there's several things that you need to do, including getting that home title to a trust, which your estate planner should take care of. Retitling your bank accounts, which is a really important part of it to make sure that you do have a trust account set up. And that kind of goes back to one of the concerns that we had when someone, and the question you asked in the beginning, when someone sells a house that's in a trust, how does that work? Well, I just talked to someone recently who said, well, they made out the check to the trust and there was no way for that there was no place for that trust to go. Well, that means that they didn't complete the setup for the trust, which is making sure that you have a bank account that is owned by the trust. Okay, so you have a trust account for those funds to go in. Now, if you skip that step and your home's in a trust, then you just have to go through the process of opening a trust account, which you can still do, and deposit that check. It's just a little bit of a delay when you don't want a delay. I don't want that delay for you. So that's part of the checklist of things that you need to get done with us within the first 4 weeks of having a trust. So if I said, oh, just put your house in a trust and you don't have to do anything else, well, we have a whole list of things that you need to do. There is some setup. But if you're willing to do those couple extra steps and learn how it works, it is slick as anything for the people that you love. And that's our goal with planning. Now, if you don't have a trust, I'm sorry, if you don't have a house, that's one reason that some people don't use a trust. Or say, for example, you have someone who, let's say you have one child who lives in the house and they're going to keep the house. And we're just going to let the default laws of North Carolina kick it to that one child. And then they will just live in the house forever. And that's the plan. Then I'm not so concerned about that passing that way through the default laws. But if you have, even if you don't have a house, if you have minor beneficiaries who could potentially be given an inheritance when they are only 18, and we know their frontal lobes need at least 8 more years before they have some control, impulse control, then sometimes we like to do a trust just to capture that, just to make sure that they don't get too much at once outright in their laps. So legitimate reasons not to put a home in the trust is if you don't want any kind of hassle, you just want it to be as easy as possible for you, well, just go to willsandtrust.com and create something. And you don't care what happens on the back end because you're like, hey, you're getting free money. Duke it out in the probate court. I don't care. I'll be in heaven with Jesus. That's all I need. Then I would say don't, if you're not concerned about the outcome or someone interacting with the probate court, then that would be a legit reason to not put it in a trust. And some people don't care. That's why I say I want to look at your eyeballs as we're talking about the law to see how much you care, because that is really important. Okay, I see from Carol, is the mortgage on my home affected by a trust set up? There is a really cool law. It's called the Garn St. Germain Act that says if you transfer your home to a trust, a mortgage company cannot call the loan because you did a transfer. This is not the kind of transfer that would cause them to call the loan on your mortgage. They literally, by law, can't do that. And as long as someone keeps paying it, it's fine. The law protects this for the purpose of estate planning. Um, okay, let's see. Carlton, you have, and I'll do the price range after this question. Can there be two trustees or only one? Well, my favorite is only one because then they don't have to fight and you don't have to spend money in court while trustees are fighting. If we ever name two trustees, I like to have a tiebreaker. Someone listed that is like, hey, if these two don't get along, we don't want to go to court. Just let my neighbor Janice resolve the conflict. Okay, we can do that. You can avoid court by just being smart about how the trust is drafted. But that's a great question. Um, okay, so the cost of setting this up for revocable living trust. So I can give you an idea of kind of what the price range is. And I'll tell you, you can get cheap, I think I've said this a couple times. You can get cheap wills and trusts, but I think we've made the point that's not the whole picture. Okay, so if you are shopping for just price, I strongly discourage you to do that because you're going to land at a place that doesn't do all the steps to make sure this is done correctly and we have the outcome we paid for. As a matter of fact, we see this all the time. People come, they're like, I have a trust, it's right here. And I say, what's in the trust? And they're like, I don't know what you're talking about. Well, now it doesn't matter that they only paid $2,000 for this trust 5 years ago. They got absolutely nothing because they didn't do part two. Okay. So for us, the price range for our estate plans are start at 2,500 for like a will-based plan, 2,500, and then we have some options. We have some extra fancy things you can even add to a will. Okay. But will-based package starts about 2,500. Trust package starts at 4,500. And we have $2,000 questions. And I'm just telling you this is us. And you can price shop if you want to. But we have $2,000 questions. One is whether or not you're creating asset protection and leaving something for your spouse in trust instead of outright, and whether or not you're creating a trust for your kids. So those would be the two things that would increase the price. But we also have concierge where you're like, I really want this trust, but I know I'm not going to follow through. But I really want to do it. We do have a higher plan that's a little bit more where we do all the legwork for you. All you have to do is sign a stack of papers and we'll get your bucket funded. We'll get your wagon full and everything will be great. So does that answer your question? I think that's the range, like 2,500 to 8,500 is kind of where we are. Okay, great. Okay, I see Crystal's question. If you have a home in an LLC, what's the downside if the trust is designated in the articles as the owner of the LLC? There's no downside like that. So that means that you just started with the trust and you owned it originally. You opened the LLC, um, and the trustee, you're owning that share as the trustee of the trust instead of as your individual self. That's what we're trying to create. A lot of times people have already created the LLC, and we're trying to create exactly that, Crystal, by doing an assignment to the trust. Now we put it in the hands of the trustee. So if it's already written into the LLC because the LLC owns that interest, that is perfect. That is great.
I have
Okay.
a
Are those?
couple of questions that I wrote down as you were talking earlier.
Yeah. Mm-hmm.
One of them was about when you move. I know you talked
Mm-hmm.
about if you have a property that's in a different county,
Mm-hmm.
or if you have a property in a different state and you moved to North Carolina. What if the opposite is true? Like if you
Mm-hmm.
own a property in North Carolina and then you moved out of state, is it
Mm-hmm.
then going through both, again, both states probate as well? Will you just
It
speak to that?
can, but if you buy, let's say I move to New York from North Carolina, I would just purchase my new property as the trustee of my trust. Now it's owned by the trust. Now there's a practical implication in that if I do die in New York, we're going to have to straddle the laws of two jurisdictions. And if I'm really going to live there, I'm probably going to die there. And I will probably want to update my trust to New York documents, but I don't have to. I can still avoid probate by doing it to the trust. So we have this, if some people have like multiple second homes and they just want to put them straight in the trust, all their homes, I don't care if it's in Wyoming or Maryland or wherever, can be owned by your North Carolina trust and avoid probate everywhere.
Okay, thank you. And I think Carlton kind of piggybacked on this in the comments. He said, can you sell a property put into a trust? Oh, yeah, that's a great question. We had mentioned that on
Yes,
the front end of this.
absolutely. The way the property works, just think of that little girl with the wagon. She can still grab stuff in the wagon and toss it out, and she could pick up other things and put it in the wagon. While you're alive, then you can put stuff in and out of the trust, and the trust is revocable. Like you could revoke the trust entirely. We don't want you to do it unless you talk to your lawyer, but you have full control, and there's not even a special like EIN number or anything. This is all under your own social security numbers. There's not special tax implications or anything. It's actually once you learn how it works, it's just kind of this pass-through thing that does magic on when you die. And I really do think it's magic. Avoiding probate, I think, is a beautiful thing.
Perfect. And then one more thing on my list is talking about the right of occupancy. I know you were
Hmm.
talking about that and designating someone. I'm assuming that when you have a trust, whoever the trustee is, when they acquire that property and said trust can kind of do as they please if they decide to sell it or if they decide to occupy it.
Hmm.
You're saying to designate a right of occupancy if that's not the person who is the trustee or if there's multiple
Yeah.
people, right?
Yeah, let me give you an example so you can kind of picture this. We have an aging couple, and they have an adult son that's lived at home, and it's very clear that he is not going to live on his own. Maybe we have severe anxiety, depression, something else going on. He's very comfortable, can go to his job every day, but maybe not handle all the expense of taking care of everything. And you're worried, almost like the same as you would with a special needs child, which this would work for them too. But some people, I feel like this mental illness piece is really something that people, this generation struggles with. We're not out in the sunshine. We're eating processed food. For all these reasons, we have these mental illness problems. And so imagine that that son could continue after you are gone to live in that house with the neighbors close by, going to the church that you go to, the things that are comfortable. And the trustee is making sure that the property taxes get paid, that the home's insured, that the roof gets repaired It needs it. You've left aside some money to fund this right of occupancy, and this child can go ahead and keep living their life comfortably for as long as there's money to fund that. And the cool thing with that is it sets up the rules so there's no conflict around it. The trustee has like a right of entry and things like that. It's really spelled out.
Perfect. That's what I needed. Thank you. We have a
Mhm.
few more questions in the chat if you want to hit those next.
Okay. If the trust is set up with you, what is the process when the last spouse dies? Do the kids just call you to take over? And is there an additional expense? So, what you're talking about is trust administration. And trust administration is so beautiful compared to probate administration because it can happen quietly in the office. You probably have a trustee, if we've helped you guide to picking someone who's really organized and good with money, that can work through, literally read the trust and do what it says. They might want to link arms with a CPA, depending on what your net worth is, and just get a second pair of eyeballs on the tax situation to administer everything. But all of that could literally be taken care of privately without lawyers if the trust is set up correctly. If it gets tricky, then lawyers can step in and help with some trust administration, and there would be fees for that, but so much less than a probate proceeding.
Okay, and then I think there's one or two.
Okay.
You
Will and a
mentioned,
trust that conflict, which one's preferred and why? Okay, so when you have a trust, it's a common thing to have a pour over will, which is like a sidecar to that trust, in case you leave property outside of the trust accidentally. Let's just say that you bought a piano on one day and you died the next day, and now this piano is part of your probate property. It never made it into the trust. The pour over will catches the piano and pours it back into the trust. Okay. That little pour over might need to be probated. Not everything, but just that one piano or maybe the one car that we left out of the trust. So you do need that pour over. What happened with the one I was telling you about is the will that they created with this online thing, and they didn't even know they had created a trust, but the will that they had created was a full will, okay? Because that's what they had planned out. They didn't know they had created a trust. They had different provisions in the will and the trust, all executed the same day. All these would conflict with each other. And now we're going to the default laws in North Carolina as if no planning ever happened. Okay. All has to be probated. So, not fun. If you obtain assets after the trust is already set up, can we just designate the trust as the owner, or is it better to change the wording in the trust? It's a great question. And often we're talking about tangible property. And we give you a schedule so you actually don't have to update your trust. You have an extra piece of paper that your trust refers to. And you can actually list out that asset and say who gets it, and it's tied to your trust. And you by yourself can revoke it by tearing it off, tearing it up, and create a new one and sign it. So you can actually watch how your beneficiaries are acting and disinherit them in real time. Okay, it's kind of fun. Or you can pretend like you're going to disinherit them. I don't know.
Crystal
Awesome.
said awesome. Yeah. Any other
Crystal, it
questions?
is awesome. That's great. Do you want me to go to the little offer? I have a little overcome your procrastination offer that I want to share with you. Just before we go, and this triggers a whole conversation. It's what I love to talk about, and I'll just kind of let you know what we would do next if you wanted to move forward with us. Here is your estate plan procrastination buster. It's $1,000 ticket, and we're going to make it really easy for you. If you're right on the edge, maybe this will help you get over your procrastination, which is my goal in life. So to claim your $1,000 golden ticket, there's 3 steps. First is to book a consultation time online to chat with us and schedule a 2-hour planning session. And if you scan that QR code, it will take you to our website and you can click on the consultation link to get a consultation with me. I also have an associate attorney McCall. So if I'm booked out a little bit and you want to get in sooner than later, you can click McCall and you'll actually get two attorneys for the price of one. So I encourage you to do that. That planning session is a $750 value. Okay, so that's the first part of your golden ticket. Now, you secure your planning session in step 2 with a commitment to complete your homework within 3 days. This is how you get the 750 waived, is seriously, you just complete the homework. That's it. It takes about an hour to do, and we love to have it done 3 days within 3 days of you booking the consultation. If you do that, we waive $750, and you can decide whether or not you want to do estate planning with us during that 2 hour planning session. So there's really no obligation once you have the homework completed. And then step 3 is to keep your original appointment. And we do this because we do block out 2 hours of attorney time to meet with you. And it's really important that we can count on those appointments. So if you keep your original appointment and you mention Choice Residential Real Estate, then we will give you $250 off any estate plan package. So let me know if that was clear or not.
Yes, that's wonderful. And wow, thank you so much. Thank you so much
Yeah.
for both that and for all of your time today. This was so valuable, and I know everyone here really appreciates it. Thank you, everyone, for attending today. We'll get this recording out to our agents. And so if you are a homeowner that tuned in today, um, just reach out to your agent. They'll reach back out to you and send you this link so you can watch it back. Like we said before, I know sometimes it's worth repeating and soaking it in a few times, but Deb is here to be a resource to you. Deb, thank you so much for your time, and to everyone, thanks for joining us today.
Yeah, thank you. Thanks so much, Kate.
Bye, y'all.